Okay.
Hi, everybody. Welcome to this week's webinar on trademark options. Today, Matt Grumbling is going to talk to us about federal, state, and common law protections. I will be recording this session so that if you want to go back and watch it later, or if you think you've missed something, you can go to the Surprise Economic Development YouTube page. And all of these webinars, if you've missed one before or the one last week, you are able to access all of them. So welcome, Matthew.
Thank you, Julie. Glad to be here again.
I'm going to hand this over to you.
All right, thank you. So as Julie said, my name is Matt Grumbling. I'm with Wynn Tarbett, LLC. We're a patent and trademark law firm. And we also do other things that are related to those things, but primarily we do patent and trademark law. And my contact information is up above. You can email me anytime you like. Today's presentation is the second in the series on trademarks, and we're going to be talking about the options you have in filing trademarks or dealing with trademarks. I've listed these kind of in the opposite direction or opposite order from what I'm going to talk about them. Let's say federal, state, and common law protections. I'm actually going to, if we go on to the next page here, talk about common law protections that you have basically by operation of law, no matter what you do. State trademarks, federal trademarks, and also international trademarks. So there are some common law protections that you have just as a matter of doing business. One of them is common law fraud. And now the thing about common law fraud is that there's a requirement that you prove that there is an intent to deceive, and it has to be a specific intent to deceive. And that can be a little bit difficult to prove. It's at the very least you have to prove somebody's state of mind. Now it can be inferred from the circumstances, but at the very least, if you sue somebody for common law fraud, you have to specifically allege a particular state of mind for that individual, and that's harder to prove than just that somebody did something. You have to prove that they had a particular state of mind. Actually, the common law fraud it comes under both civil and criminal statutes. So if you find that somebody is committing a fraud, let's say fraudulently setting a business that they try to pass off as your business, you can complain to the authorities, to the police, and swear out a complaint. And if the authorities feel like they have a good case, they may prosecute that as a criminal matter. You can also bring a suit in civil court. So those are both options there under common law fraud. There's also such a thing as tortious interference with a contract. So tortious it's a tort, and basically if somebody interferes with your contractual relationships with another party by trying to pass themselves off as representing your business or somehow being associated with your business, you may be able to show. Again, you'll have to show some level of willfulness or intent there in order to prevail. But that's available, and oftentimes when trademark issues come up, these are both common law fraud and tortious interference with contract end up being pleaded as alternative theories to the trademark complaint. And then there's unfair competition, and unfair competition, it basically is kind of the umbrella under which trademark infringement comes, but it's a common law protection and deceptive trade practices. These things actually, again, these have both criminal and civil components. So you can you know, if you can get the authorities interested in your case, you know, and what you'll really have to show there is probably more than that you were harmed. You'll have to show that some, you know, some consumer, because these are consumer protection devices or consumer protection statutes. If you can get the authorities interested in it to protect the public, they may very well do your dirty work for you, and you know it's not a bad thing if you can get the authorities to help you out. So now state law trademarks, state law. So the 50 states, generally speaking, have some sort of trademark protection. They are now they allow you to register a word or a name or a symbol or a device or any combination thereof in order to identify goods made or sold and to distinguish them from the goods made or sold by others. So that comes out of the Arizona revised statutes, and they're pretty similar requirements throughout the 50 states. And in fact, that sort of mirrors what the federal trademark law covers. What can't you protect? Basically generic terms that are merely descriptive. I'll talk about those concepts more when we get down to the federal statute. But you know, if you try to trademark a word that that's in common usage, let's say, you know, the computer store. Okay, well that's you know, and you sell computers. That's a generic term. You're not going to be able to keep other people from using computer store in the name of their business, especially if they're now if you call it the computer store and it's and what you're really selling is stationery. Well, you know, maybe, you know, because that's now you're starting to get into the world of well, you're just getting into a different universe, and I'll talk about that a little bit later on. But you know, basically, if the word is generic or merely descriptive of a particular type of good product or service, and it, you know, and it's associated strongly with your you know, what you're offering, you're not going to be able to protect that. Now, the state may allow you to register it. It may have never been used before, and they may allow you to register it, but those registrations don't mean a lot because they're not examined the way federal trademarks are examined. So you know, you may end up with a registration that you can't enforce in court. So there I've gotten these two, generic terms and descriptive terms. What uses can you protect against? Well, you can protect against any use that is confusingly similar to yours. And the use has to, you know, it's the mark itself associated with particular goods or services. It is possible, let's say, it is possible, but I'll give you an example. The name Apple for computers. Now, Apple is a word that's readily used in the English language. I had an apple after dinner last night, for instance. So now if I tried to start a business that was called Apples and I sold, among other things, apples, that wouldn't be protectable. But Apple computers, assuming it hadn't been used before, I could use. And I could keep others from selling Apple computers. You know, so now obviously Apple's already taken, somebody else already thought of that idea and they've already registered as a trademark. So I won't be able to do that. I'll have to pick some other fruit or vegetable or something like that. But that's where you can see the use has to be similar to yours. So let's say if I came up with Apple garden supplies, maybe that's protectable. I guess we really stretched garden supplies out. It might cover apple trees, but let's just use our imagination and say that that would be only merely suggestive of garden supplies. So apple garden supplies. Could I keep Apple computers from using their trademark? Let's say, for the moment that let's presume that back in 1969, I'd registered Apple garden supplies. Could I keep Apple computers from trademarking Apple computers? And the answer is no. And the reason is because it's a very dissimilar use. And the example I used last week was Apple Music, which is owned by the Beatles. They were not able to keep Apple computers from using the trademark Apple in association with their computers. But when Apple started getting into the music business, that was a different story. So they were able to. They actually ended up having to work out a deal for that. By the way, Apple has a lot of money, so they're you can buy a lot with that money, including trademarks. Some advantages to state law, trademark law, and there are some disadvantages. So let's talk about the advantages and disadvantages. One is that they're quick. They're not only quick, they're relatively inexpensive, and they don't get examined, so you can get your registration very quickly. You get a priority date. Okay, it's going to be some sort of evidence that you were the first user, if indeed you were the first user. It gives you a date that you can point to and say, yeah, we've been using it, since whatever your date of inception was, and as evidenced by the state law registration. Like I said, they're inexpensive, but a disadvantage to them is that they're state specific. So, if I register my trademark here in Arizona and somebody starts to, somebody opens up shop right across the border in New Mexico, I can't stop them. I just don't have a leg to stand on there. You can register some names here in the state that might not be accessible in other, through the federal statutes, like surnames and geographic names. Another disadvantage to state law trademarks is that you can only file in state court. There's no federal cause of action. So now, I say that you might be able to sue, using diversity jurisdiction, but the amount in controversy has to be $75,000 or more. So in general, you're going to file in state court. You're not going to have access to the federal courts there. Let's see. So what is a trademark? It's an indicator of source. I showed this one last week, but I kind of like it because it's just a good graphic. You can have word marks like Walmart, Apple, or Amazon. You can have symbols, whatever that thing under Walmart is, the apple under the apple, the smiley thing under Amazon. Or you can have combinations of those, right? And you'll see registrations, and the Amazon one is cute because if you look at this, the smiley thing with the arrow is suggestive of A to Z. They cover everything from A to Z. So it's very clever. It's a very clever mark, and you can register each of those independently. So you can register the word mark independently of the symbol mark, independently of the combo mark. And it's probably good to do all of those because somewhere along the way, somebody's going to want a copy. If your trademark catches on, somebody's going to copy. And then there are others. There's the the Intel chime, and colors. A famous case that I guess about 20 years ago, where a dry cleaner actually trademarked a color that associated with their hangers. I thought that was interesting. So federal trademark protection, this may look familiar to you because it actually comes straight out of the Lanham Act, but it looks like it's about the same definition as you find in the state trademark protections. So in order for it to be a unique indicator of source, the word mark or service mark, but a trademark or service mark, which is a word, it needs to be fanciful or arbitrary or suggestive. It can be descriptive, but in order to put it on the principal register, you have to have evidence that the mark has attained secondary meaning, such that the people who are involved in that particular market, the customers in that particular market, associate it with a particular good or service. And finally, it can't be merely generic. So again, and I'll give some examples here in just a second. So here's fanciful, arbitrary, or suggestive. What do we mean by fanciful, arbitrary, or suggestive? Well, fanciful terms are terms that just are made up. They're brand new words that nobody's ever seen before they're used as a trademark. They're words like Exxon. I remember back in the day, there were a number of different companies that actually eventually flew the Exxon banner. Esso was the biggest one. And Exxon rebranded itself and named themselves Exxon. Why in particular they picked that is not clear to me, but one thing is for sure. Nobody walks around misusing Exxon as a way to pick up office supplies or something like that. We don't go down to the gas station and fill up with Exxon. So in that sense, it was, can't be a generic term because it's completely made up. And as long as, and here's the other part of it, you have to guard yourself if you're the trademark owner against having your trademark misused as a generic term. I'm not really going to delve into that very deeply, but there are lots of examples. They tend to be older examples because companies are a lot more sophisticated now about guarding against the misuse of their trademarks as generic terms. But there's some that tread dangerously close to it. Google is one of them. I'm going to Google something. It's become a verb, and that's actually treading fairly close to that line where it's become generic for searching something on the internet. Now, Google's involved in quite a number of other things, and I think we all recognize that. But back in the day, the term aspirin for acetylsalicylic acid, actually, aspirin was a trademark, was a trade name that ended up becoming genericized. And so it's no longer registrable because it has become generic. Another is refrigerator for an electronic cooling cabinet or whatever you want to call it. We just call it a refrigerator now. It was actually a trademark that ended up becoming genericized because the company that sold refrigerators should have been refrigerator brand electronic ice boxes or something like that. And they didn't go to the extra mile of linking the trademark with a generic term, where the generic term would be clearly the generic term. One that I think treads very close to this today is the term Kleenex. A lot of people say, hand me a box of Kleenex. Well, Kleenex is actually the trademark for facial tissues. So hand me the Kleenex brand facial tissues, please, you might say. That would be the correct way to say it. And there are also a lot of other examples. If you pick up a writing magazine, you'll see examples of those where the trademark owners are warning writers not to misuse their trademarks. That day glow orange refers to a trademark name for a particular type of fluorescent orange. So you will get a registration as long as you've been careful about picking the fanciful words are the best. They're the most powerful trademarks. They're the hardest to challenge, and they're also the ones that end up over time becoming famous marks that you can sue somebody for trademark dilution if they infringe your trademark. Anyhow, I'll go on. Pepsi's another example, and there are hundreds of them. Arbitrary ones. These are English words that have been repurposed to serve as trademarks. And I've already mentioned Apple Computer, but there are other examples. And then there are suggestive ones, and these require imagination, thought, or perception to reach a conclusion as to the nature of those goods or services. And I mentioned, Apple garden supplies might be an example of a suggestive trademark. So, something along those lines. The computer store for selling stationery, that might even be considered arbitrary. So the line between these is maybe a little bit, it may be a little bit gray, but you're on safe ground here if you come up with fanciful, arbitrary, or suggestive type of trademark name. Best Buy might be considered suggestive. I think it's a big box computer store, but in comparison, maybe Target would be fanciful or arbitrary. I'd say it's arbitrary because it's an English word. Nobody made the word up, but it's arbitrary. By the way, we'll get to that in the next slide here. Then there are descriptive or generic terms. Now, descriptive terms, they just describe or deceptively misdescribe a good or service. So if it merely lists an ingredient, quality, characteristic, function, feature, purpose, or use of the specified goods or services, then then you have to, for descriptive marks, you have to show a secondary meaning. And normally you can't show that when you first apply for the mark. That has to be done later on. So here are some examples. Register of bed and breakfast is descriptive or generic. Chiropractic medical room, that's definitely descriptive or generic. So naming the good, generic ones name the goods or service. And examples are, the bakery for a bakery. Now you named, if you had, let's say, a computer store named the bakery, that's starting to get into the arbitrary realm, isn't it? But the bakery for the bakery, skin doctor for a dermatologist, yeah, you're not going to get that. So I mentioned the principal register before. So the federal registration process gives you access to two different registers. One is the principal register, the other is the supplemental register. Generally speaking, you want it on the principal register because that's where you get all the protection for the principal register. Secondary register is there because you can park your trademark there. It confers some benefit of priority to you. And if let's say your mark is purely descriptive, you can over time develop that evidence for secondary meaning of association with your source, and you can later on present that to the patent office and petition them to move your mark to the principal register. So one advantage of having your mark on the principal register, and again, in the first instance, if you have a fanciful or arbitrary or suggestive mark, those can go on the principal register to start out. And provided nobody else has used them before in association with that particular good or service. So you get a nationwide constructive use and constructive notice. So the nice thing there is you don't actually have to start using it yet. You actually file first, get a tentative approval, and then later on prove that you've used your trademark in commerce. Let's say you have been using it in your home state, but in order to get a final registration, you need to use an interstate commerce. You can file for registration on the principal register, get a tentative approval, and then later on prove your use in interstate commerce, and thereby get a registration on the principal register. After 5 years, your mark becomes incontestable. What does that mean? Well, it means it's going to be very hard for somebody to prove that they either used it before you did, or that you're not eligible. It's not eligible for registration because it doesn't meet one of the requirements for trademark registration. One of the nice advantages to being on a principal register is you can sue in federal district court for trademark infringement, and there's no requirement that you meet the $75,000 amount in controversy requirement, or that you show that diversity and the defendant or the defendant. And that's something that, as a business owner, you're probably not thinking about, but it's definitely something your litigation counsel would think about. And here's a really nice part of being on the principal register. If you have a valid, current registered trademark, and somebody tries to import goods that fraudulently use that trademark, you can file suit against them, actually, in the ITC, the International Trade Court, and they will enlist the federal customs agents to bar importation of those infringing goods. In fact, you can actually get them impounded while the ITC is investigating. So that's super nice. That's again using the police powers of the state to your advantage. You don't have to go out there and practice self-help, and you don't have to sit around and wait for them to sell all the goods and then sue them for damages. You can stop them right at the border. And that's, in these days of knockoffs coming in from all over the place, that's a really powerful thing to have. And the other thing is, if you can show that the infringement is willful, which isn't easy, but it's possible, you can get up to treble damages. That's triple damages, and or attorney's fees. So you can make the other side pay the full cost of the litigation. If they're smart, they'll take the hint and they'll back off when you send them your cease and desist letter. But if they continue down that road, you can get up to triple damages. And by the way, those damages can be everything from disgorgement of profits, or they can be a reasonable royalty of some sort. You can also use this principal register registration to cancel domain names with ICANN. So those are all powerful things you can do if you're on the principal register. The supplemental register, as I said, is a place where you end up parking certain ineligible marks, waiting to try to develop the evidence of secondary meaning, so you can move it to the principal register. But it does give you some powers, some rights. For one thing, you can try to register in other countries under the, well, let's see, that's the first, okay. So it permits the owner to file for trademark registration in other countries. Now, under the Paris Treaty, specifically Chapter 4, you have 6 months to file for trademark registration in other countries, keeping the same priority date that you have in the US. So that can be very useful to you if, let's say, you're planning on launching something in, say, let's just pull in our head, the UK. So you file here in the US on January 2, and so by June 2, you'll need to file a trademark registration application in the UK, and you may run up against the same problems you run into in the United States, but at the very least you have some foothold there, and if you have to prove secondary meaning, you can. Again, you can sue in federal court, but you don't get the same kind of presumptions, and then it doesn't become an incontestable mark after a period of time. So it can be contested, even if it's been 5 years parked on that supplemental register, and there's no presumption that it's valid. So that's definitely a downside. And you can't use it in ICANN to prove to permit cancellation of a domain name because it's descriptive, and ICANN just can't cancel every URL that describes things. So so that's pretty much it about the. Like I said before, it can be upgraded to the principal register if you meet certain conditions. So let's talk just a little bit about international registration for the last few minutes. So if you get a registration on the principal or supplemental register, then you can, that gives you a priority date for filing for trademark registration in countries that are members of the Paris Convention. And that's most countries. There are definitely exceptions to that, but the Paris Convention has been around for a very long time, since the late 19th century, and most industrialized nations are members of the Paris Convention. So again, I mentioned this. You've got 6 months to file. And that's nice. It'd be nice if it were a year or something like that. But you got 6 months, which means you've got some time to, do a little bit of market research and figure out whether you really want to spend the money on a particular place or not. I mentioned Paris. It's Article 4 that gives you this power. You still have to comply with the local laws and rules. So if it's on the supplemental register, and it's there because it's merely descriptive, then in the place where you file doesn't allow descriptive marks, you're not going to get a registration there either. But if they allow you to perfect that mark by showing secondary meaning eventually, then you eventually could get it. So it gives you, again, it's a foothold, it's a place marker. It's kind of like leaving your hat on a seat to save the seat. There's no guarantee it's gonna be there when you get back, but it at least gives you a shot, right? And that's the end of this presentation. I welcome any questions or anything like that, but yeah, that's it. Hey, Julie.
Hi, well, thank you. That was definitely very interesting. Lots of good information. We don't really think of trademarks every day, but that was very good. I learned a lot, and thank you very much. We appreciate you. Now, we'll be having, we're not having a workshop next week because of the Thanksgiving week. So we will see you all back here on December 1st, where we will be talking about trademark licensing and options for monetizing your brand. So if anybody has any questions or you missed part of this, you can go back and you can watch it. And Matthew's contact information is on his presentation, so feel free to reach out. And thank you again, and we'll see you all on the 1st of December, and have a happy Thanksgiving.
Thanks, Julie.